Hello, and welcome to this Australian-New Zealand Women's Declaration International webinar for August 2024. Janet is the New Zealand country contact for the Women's Declaration International and a policy convener for the Women's Rights Party New Zealand. She has been active promoting women's sex-based rights in New Zealand for several years and helped to set up several groups who work to protect those rights. She is a mother and a grandmother. Janet has been concerned for some years about proposals to add gender to the Human Rights Act, which she has consistently opposed. Tonight, she will talk about proposals from the Law Commission to add gender identity and gender expression into the Human Rights Act and why this is a bad idea, focusing on how it breaches the Convention for the Elimination of All Forms of Discrimination Against Women, CEDAW. And now I'd like to hand over to Janet. Janet?
Kia ora koutou katoa. I'm Janet, and I'm the New Zealand country contact for Women's Declaration International, as well as I'm a policy convener for the Women's Rights Party, and I've also had a little bit to do with the WDI UN committee as well. So I'm going to talk about why gender should not be put into the Human Rights Act, and I'm going to talk quite a lot about CEDAW and how these proposals would conflict with CEDAW. So yeah, I'm talking about this Law Commission issues paper, which has just been released, as Jan Rivers said, called A Review of the Protection in the Human Rights Act 1993 for people who are transgender, people who are non-binary, and people who have an innate variation of sex characteristics. So they've reached a preliminary conclusion which says an amendment to Section 21 is necessary and desirable to ensure adequate protection from discrimination to people who are transgender or non-binary or who have an innate variation of sex characteristics. And by that last category, they mean people with DSDs. Differences of sexual development. Notably, although the Human Rights Commission thinks protection is already available under the sex ground, it also thinks reform is needed to clarify the law, and that's because, as Jan mentioned, the Crown Law issued an opinion in 2006 saying that people with gender identities were protected by the sex category, but that's never really been proven, and it's in fact highly questionable, and the Human Rights Commission knows it's questionable, and that's why they still want the law to make sure that gender people are covered. But okay, so moving on. So, you know, my basic stance is that gender harms women's rights. I think most of us nowadays who are gender critical have this view. It's a vague, imprecise concept, creates bad law. It's another name for sex-based stereotypes. Women's rights are sex-based, women's oppression is sex-based. When gender is introduced into law, it conflicts with and may eventually replace sex-based rights. Women can only fight for our rights if we can name who we are and what our oppression is. So the Convention on the Elimination of Discrimination Against Women, that's CEDAW, is definitely sex-based and provides sex-based rights for women. And as Jan Rivers said, you know, they hardly mention CEDAW, and she only spotted it where they are trying to incorrectly use it to say that it's protecting the rights of trans women. And I spotted it in one place where they're talking about how the current CEDAW committee is now asking New Zealand to do more for trans women. But that to me is just an indication that UN is starting to get captured now by gender activists, but definitely that is not what CEDAW was about, and everybody knew that for a long time in the United Nations. So Article 1 of CEDAW says, for the purposes of the present convention, the term discrimination against women shall mean any distinction, exclusion or restriction made on the basis of sex, which affects women's human rights and fundamental freedoms. I'm not going to read all the words that are on my screens because I won't have time. So Article 5 of CEDAW says, states parties shall take all appropriate measures, and here when I've got stuff in blue, it's probably something to do with gender, to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and other practices which are based on the inferiority or superiority of either of the sexes or stereotype roles. So CEDAW sees these cultural patterns as being stereotypes which should be opposed, in fact, eliminated, certainly not supported. So in 2010, the CEDAW committee definitely at that point still understood what CEDAW was about. And their recommendation 28 said that it started to look at, well, does CEDAW have anything to do with gender? And it said, the convention only refers to sex-based discrimination because it doesn't mention gender at all. However, interpreting Article 1 and Articles 2 and 5 indicates that the convention covers gender-based discrimination against women. The term sex here refers to biological differences between men and women. The term gender refers to socially constructed identities, attributes, and roles for women and men, and society's social and cultural meaning for these biological differences, resulting in hierarchical relationships and in the distribution of power and rights favouring men and disadvantaging women. So that's what the CEDAW committee was saying in 2010. And Reem Al-Salem comments on this recommendation 28 when she was asked to help provide a definition of women for the Tickle versus Giggle court case, which she didn't end up being able to be a special friend of the court, but she wrote gave some advice anyway. So she says, talking about the CEDAW committee recommendation, in the position paper on the definition of woman in international human rights treaties and in particular CEDAW, she said it is clear that the CEDAW committee did not equate a person who may identify as a woman and a man with someone who is a woman or a man, the latter being defined either as biologically male or female. And Reem Al-Salem is the Special Rapporteur against violence against women and girls, if people haven't heard of her before. And she also said, while not addressing or defining the term sex or gender, many foundational human rights treaties and declarations, including CEDAW, enshrine a prohibition of discrimination based on sex, which can only be taken to mean as referring to biological sex. And this was reinforced by recommendation of the CEDAW committee, that the whole purpose of CEDAW is the elimination of all forms of discrimination against women on the basis of sex. Furthermore, Reem Al-Salem says that sex and gender are two different concepts where tension may arise between the right to non-discrimination based on sex and non-discrimination based on gender or gender identity. International human rights law does not endorse derogations from the obligation to ensure non-discrimination based on sex or the subordination of this obligation not to discriminate based on sex to other rights. So CEDAW says you can't replace sex with gender or make gender more important, but this is what countries are trying to do around the world and is what happens in practice, but it's actually breaking the CEDAW, their obligations to CEDAW. And here's a definition of gender from the United Nations. Gender refers to socially constructed differences and attributes and opportunities associated with being female or male, and to the social interactions and relations between women and men, and it's all about inequalities between the sexes. So the Women's Rights Party says something pretty similar. Gender is an imprecise concept that refers to sex-based stereotypes and social expectations, i.e. what is considered feminine and masculine. Gender identity and expression refer to the identification with and expression of those stereotypes. The United Nations didn't just, of course, have CEDAW. There are a number of United Nations conventions, and I would just like to refer to one of them, which is some United Nations rules for prisoners, which are being broken in New Zealand prisons, where they definitely specify that women prisoners should have their own separate institutions. That's in the Mandela rules. Nelson Mandela rules, and the Bangkok rules emphasises the importance to highlight the distinctive needs of women prisoners and take positive measures to address structural causes of violence against women. whereas in New Zealand, we've had violent men in women's prisons. And this is just on the interpretation of the current Human Rights Act, which is incorrect. So this was the old idea about what gender was and how important sex was. But gradually the idea of gender is being changed, and instead of being seen as a cultural construct, it starts to be seen as an inherent internal and individual identity. And this is what the Yogyakarta principles were saying in 2010. It's each person's deeply felt internal and individual expression of gender, which may or may not correspond to the sex assigned at birth. And this was a group of men, I think mostly gay men, who got together on an island and wrote it, but it has absolutely no validity in international law. It's never been adopted officially by anyone. The Women's Declaration is highly critical of that definition by the Yogyakarta principles. And it says that gender identity maintains women's inequality. It says the concept of gender identity makes socially constructed stereotypes which organize and maintain women's inequality into essential and innate conditions, thereby undermining women's sex-based rights. The concept of gender identity has enabled men to claim a female gender identity to assert in law, policies, and practice that they are members of the category of women, which is a category based on sex. And they also talk about how it undermines lesbians because they no longer have the right to be same-sex attracted. And they also talk about how the erasure of sex is happening globally. There's a really good article called The Erasure of Sex, the Global Capture of Sex, the Global Capture of Policies on Sex by Gender Identity Activists and the Effects on the Rights of Women and Girls. You can find this on the Women's Declaration website. And it talks about steps to eliminate the legal category of sex, which starts with something fairly harmless, like apparently harmless, allowing change of legal sex under restricted conditions. And that actually happened in 1995 in New Zealand, in the Births, Deaths and Marriages Act that we had then. And you move down the steps until you come to step 4, biological sex is treated as private information and its disclosure is punished by law. Step 5, sex is replaced. The legal sex category is replaced with A, sex characteristics, B, gender identity, and C, gender expression. And we already see those 3 categories being quite promoted by the Law Commission. So Women's Declaration, of course, supports sex-based rights, and there's a whole list of all the articles are all about women's sex-based rights, which are based on CEDAW, and the Women's Rights Party has a very similar set of rights and principles. And also important to the Women's Rights Party is the freedom of speech right to talk about all these rights. So just things like having our own spaces, having fair play and safety in sports, and so on. And as soon as you get gender, these rights start to come under threat because someone claiming to be a woman who isn't can breach them. And so the Women's Rights Party proposed, has a list of biological definitions, and I think that some of these could be useful for the Human Rights Act. This would be the only change to the Human Rights Act that I would support, which would be to add a more clear definition of what sex means in the Human Rights Act. They do say sex, including pregnancy and childbirth. That's in the Human Rights Act. So I think it is indicating that the Human Rights Act intends sex to be understood biologically, but there's a little bit of room to squeeze there, which is why people like the Human Rights Commission are trying to pretend it's about gender. So I won't read all those definitions, but an example is human female denotes the sex with a reproductive system typically organized to bear offspring and produce eggs, distinguished biologically by the production of gametes, which can be fertilized by male gametes, and includes females whose reproductive system may be disordered in some way, and those females who choose not to reproduce. Like, we just felt we have to be very careful and scientific in how we define sex. And I'm actually quite astonished that laws now are trying to say that sex is not biological. I honestly never thought that would happen, but obviously it has happened in Australia and it's at risk of happening here too. And the Women's Rights Party emphasises the importance of biological sex. In its policy, it says women's and girls' sex-based rights as biological females need to be protected in policy and law, and this should not be given precedence over any proposed provisions based on concept of genders. The sex-based rights for women in the Human Rights Act must be preserved. So let's look at the Human Rights Act. It does indeed talk about sex and include sexual orientation, but it does no mention of gender in it. So there's sex, which includes pregnancy and childbirth, and sexual orientation. And then section 44 is about discrimination being prohibited when providing goods and services. And then we look at the exceptions. Section 45, this does not mean that you cannot discriminate on the basis of sex if you are, for example, giving a service for people of a particular sexual orientation, like counselling, where highly personal matters such as sexual matters or the prevention of violence are involved. And also, the next clause says, Section 44 would not apply to the maintenance or provision of separate facilities or services for each sex on the grounds of public decency and safety. So it's saying you can have women's separate sex spaces for these reasons. Now, the Crown Law was asked for an opinion in 2006 because there were proposals there to change the law and bring in gender. And the opinion of Crown Law, though, was that you didn't need to bring in more legislation because the gender people were already covered by the sex category. Now, that's just an opinion, and they weren't clear whether they meant people are protected as the sex they are or as the sex they want to be. And also, since then, we've had Section 79(2) of the Births, Deaths and Marriages Act in 2021, which makes it clear that gender identity does not equate to sex. So that puts things in a new light now in law. And here's a whole list of people who interpret the Human Rights Act already as protecting gender, starting with the Crown Law opinion. And you've got all these government bodies, councils, media, midwifery council, etc., police, who have listened to the Human Rights Council and already act as if there's already a law against offending anyone with a gender identity. But, you know, as I said, they're not really content with misrepresenting the law. The Human Rights Commission wants the law to be changed. Well, originally, as Jan Rivers was saying, there was a bill proposed, but it was dropped, I think, after the Crown Law opinion was made. So in 2023, that people started trying again. Elizabeth Kerikeri, a Green Party MP, introduced a bill trying to discriminate on the grounds of gender identity, expression and variations of sex characteristics, and that has had its first reading in Parliament and is currently supported by the Maori Party, but doesn't seem to be moving along at the moment. Now, the Law Commission has put out an issues paper, which is a review of the protections of Human Rights Act for transgender people. So here's some legislation which already includes gender in New Zealand. We've got the Births, Deaths and Marriages and Relationships Registration Act 2021. It was amended in 2021 to bring in sex self-ID, and the Conversion Practices Prohibition Act. The Births, Deaths and Marriages Act really promotes a legal fiction. It pretends that if you're born, if your birth certificate says you're born a certain sex, then you were. But as I've already pointed out, it also acknowledges that therefore the birth certificate is not a reliable evidence of what someone's sex is anymore. The Conversion Practices forbids, it kind of puts pressure on people to affirm gender. It doesn't exactly say that, but there's a lot of pressure that way. The Midwives Council, meanwhile, has been merrily trying to ban the words mother, woman and baby from their scope of practice. They didn't completely succeed, but this is the kind of thing that's going on here. We should reject it for all kinds of reasons why gender is bad for women, and it also harms free speech, which the Law Commission is trying to bring in by the back door now, some more hate speech prohibitions without calling them that. So there's ongoing confusion. Look at whether maybe we could introduce sex-based stereotypes. That that into the Act, saying we protect people for non-conformity to sex-based stereotypes. That has been proposed by the WDI in USA for their legislation, but I think it still leaves the risk that women might end up losing out, even with something as apparently harmless as that. So my recommendation is to leave the Human Rights Act as it is, with no changes to the grounds of discrimination in sections 21, except for the fact I do think that the definition of sex could be extended in the Human Rights Act to make it completely clear that sex means biological sex, and that they could use some of the definitions which the Women's Rights Party currently has. And this would end the confusion arising from the Crown Law opinion. So that's all from me. Thank you.
Thank you very much, Janet. So thank you to our NZ Aotearoa component and your discussion, which was very useful. Thank you so much.